Hello, all. Welcome to another session of Legal Essentials for Human Resource Management. Now, this is week 8 and session 38. And in this session, we would be discussing about conducting domestic inquiries in India. Now, in this entire week, we've been looking at misconduct and how to define misconduct, what are the various types of misconduct, and then we looked at once a misconduct is notified or reported, uh, you need to give a charge sheet or a showcase notice, and what are some of the fundamental principles that need to be followed while giving a charge sheet or a showcase notice. Then we looked at um, how to proceed with a charge sheet and what are the various principles that you should be aware of while drafting a charge sheet. With that information, we explained it in the last class that once a charge sheet is provided and you give enough time for the person to bring it back, and you realized after seeing his response to the charge sheet that probably it warrants an inquiry and you're not satisfied with the response to the showcase notice or charge sheet, you move forward to what we call as a domestic inquiry. So today we will look into basic details of conducting domestic inquiries, often considered to be a very technical and a nuanced skill by a lot of HR managers. But today we will try to deconstruct it and make you understand how to conduct a domestic inquiry which is legally compliant and will hold in the court if it is challenged later. So, without much delay, let's move to our session 38 on domestic inquiries in India. And I hope you know by now, my name is Dr. Ramesh Samalopanan and I'm from Nalsa University of Law. Now, before we get into the concepts of domestic inquiries, stages of domestic inquiries, we should also understand that what are the various legislations that govern domestic inquiries. So, please do understand that the principles and procedures and processes to conduct a domestic inquiry are preliminarily coming from judicial precedents. So there is no specific act or something which kind of explains how to do a domestic inquiry. So you look at judicial precedents, you'll see what courts have said over and over, and then we know how to go about it. And of course, certain laws explains procedures. For example, Standing Orders Act. Some procedural aspects of conducting domestic inquiries can be sourced from the Model Standing Orders Act and the Model Standing Order that is there. And the POSH Act, which we discussed a few sessions before, there also, if you remember that, we have discussed in detail how an IC committee should be constituted, how procedural aspects of conducting a domestic inquiry when there is a sexual harassment complaint. So we get some inputs from both this act, and we'll also look at judicial observations and interpretations as well as precedents that is in place, and then we'll figure out, or we will draw a proper way of conducting domestic inquiries. You should also understand that this Standing Orders Act is limited in its applicability since it is only applied to a certain category of employees, that is workers. So we discussed in Standing Orders Act, and the whole objective of the act is that the workers are aware of what are the rules and regulations at the place. Similarly, POSH Act is a gender specific act and it is only for sexual harassments done against women. So you'll see that in both are not all encompassing or absolute laws which cover all the employee groups and categories. Hence, we can draw basic principles from this acts, but the procedure of it largely you have to design based on judicial precedents. Now, if you remember our discussions till now, the first stage I told you, once a misconduct is reported, the first stage is a preliminary investigation. What happens in a preliminary investigation? You get a complaint against an employee for a alleged misconduct. The first step that an employer can consider is undertaking a preliminary investigation. That's why it's called as preliminary. Now, why a preliminary investigation has been done? So that the employer can prima facie come to a conclusion regarding whether this allegation of misconduct has a merit or not. So, it could be a false allegation made by someone, or it could be not even a misconduct as per the existing rules and regulations. So, to check, is this act warrants to be called as a misconduct? Is it even an actual allegation or not, or it was just a joke by somebody, a prank by somebody? So that's what preliminary investigation does. And the employer decides whether it requires a regular, full fledged inquiry or not. And needless to say, this is very informal procedure, and this is not an absolute fact finding exercise and all. And it is not even mandatory by court. So if a charge sheet is issued without a preliminary investigation also, there's no problem. And just because a preliminary investigation was not made before a charge sheet is given, no court is going to call off a domestic inquiry finding. So that is not this. The whole purpose is to decide whether the employee should be charge sheeted or not. So that's the whole objective of this particular preliminary investigation. Now, let's say during the preliminary investigation, the employer realized that it was a prank by some employee. This complaint that you received in the email was a prank. They got a mail saying that this person is physically assaulting this person in the canteen right now, and you just quickly inquire with the canteen manager. You realize that no such incident has happened at all, so you drop the case there. But in the preliminary inquiry, you realize that there is some merit to the allegation. You issue a showcase notice. So how to prepare this showcase notice or charge sheet we have discussed in detail in the previous session. So I'm not going into the depth of it. So you have to issue a charge sheet, and the whole purpose to issue a charge sheet is that the employee, the delinquent employee, will understand in detail what are the allegations against me, and then he gets an explanation. He gets to give you an explanation about why there should not be a disciplinary action undertaken against him. Sometimes that could be the reason you prima facie felt that it's a misconduct, but then once you give him the showcase notice, he or she explains to you that this is what has happened, and that's why you should not take a disciplinary action against me. You saw that an employee is coming late for 3 days. You issue a showcase, prima facie you realize, you checked with the section head confirmed, yes, this person is coming late for 3 days. You checked with the manual, it was said that if an employee comes 3 days in continuous 3 days for in late, it's a chance or it's a ground to be treated it as a misconduct. So you issue a showcase notice, and when a showcase notice is issued, the employee respond by saying that The CEO has given him another duty which you probably wouldn't was aware of. So there could be a side of the story which the delinquent employee could be having. The whole purpose of asking for a response to the showcase notice is that they get a chance to explain their side of the story. Now, a fundamental question that comes in is key, should a showcase notice be given or a charge sheet be given? Should both be given? Which one is more serious and all? So the classic case, Havaldar Singh versus Tigrania Metal and Steel Industries and others case, employer had given a showcase notice, and employee in his appeal to the Bombay High Court argued that no charge sheet was issued to him and therefore inquiry was not fair and proper. But Bombay High Court said the whole purpose of a charge sheet is that you are able to give your side of the story, which you already got a chance because they gave you a showcase notice and you had a chance to explain your side of the story. Hence, the principles of natural justice or the principle of other side should be heard is not violated in this case. So that's the answer for my question, for the question I asked. Not necessarily have to be charge sheeted all the time. You have issued a showcase notice that is good enough to be considered as a charge sheet. Now, once the response is received, you realize that now you have to go in for a regular, complete, in-depth inquiry. The next stage is to appoint a inquiry officer. Now, who is an inquiry officer? Inquiry officer is a person who will conduct the inquiry and will provide his findings to the employer or the disciplinary authority, based on which the punishment may be imposed on the accused. So employer may not be having the time to conduct detailed inquiries, look into all the facts of the case and then come to a conclusion. So employer will appoint an inquiry officer, and it could also be an inquiry committee. In fact, it is advisable that you should have a inquiry committee, because often if a delinquent employee, if a employee against whom these allegations are made, he is able to find out some link between the employer officer having some previous history against this person, then that can compromise the entire domestic procedure. So it's better that there are more people, so it kind of adds value to the decision that has been taken by the domestic inquiry. But also understand that it's better to have a odd number, because often it will go for voting, and then you realize it's a split house, equal on both sides, and then there is a deadlock. So such things should not happen. So an odd number based inquiry committee is the best thing you could do. You would have seen this in the IC committee also. It suggests that there should be minimum 4 people. So that adds that it's not one person's judgment on which future of a employee is based on. Now, now that you set up an inquiry officer or an inquiry committee, what are the functions of this inquiry officer? So the major function of this inquiry officer is to collect facts and materials for basing its conclusion. So you just cannot face read and tell if a person is a culprit or not, or if he conducted a misconduct or not. So he can collect all the facts and materials required, and he can examine and cross-examine the witnesses. So that's why if you're an employer, you appoint somebody to be an inquiry officer. It's better that you pick somebody who have a skill of analyzing all the facts of the case and is able to question and examine the witnesses, and if needed cross-examine the witnesses also. So that such a person, if at least as the chair of the inquiry committee, would do a lot of good for the domestic inquiry process. Uh, the inquiry officer should try to comply with all the rules and regulations meticulously, and give adequate chance to the accused employee to ensure that the principles of natural justice are not violated. That's another function of the inquiry officer. It shouldn't be that you just placed just paste a decision over the accused employee. Rather, you should give enough opportunity to the accused employee to hear his or her side. The inquiry officer should also clearly explain the procedure to the accused by giving him due facilities and assistance to participate in inquiry. So it is not that the inquiry officer favors one side, or favors employer who goes against this employee. Inquiry officer is supposed to be neutral. So even the accused should be explained all the procedure and be given all facilities and assistance to participate in this proceeding in the fullest capacity. Uh, the inquiry officer also should not have any bias or prejudice or conflict of interest in that matter, and should be as objective as possible. So, at any point, if the accused is able to establish that you had a conflict of interest, or you were somebody who were biased from the beginning, that can compromise the integrity of the inquiry committee or the inquiry in itself. So that is also the responsibility of the inquiry officer, or rather employer, while selecting an inquiry officer or committee, to ensure that they don't have any conflict of interest with existing with the accused. So what you could often do is that you have a permanent committee which looks into this disciplinary matters. And I'll suggest that they have more members than what is required. And any time when a new case comes in, if there is anybody who has a conflict of interest, or there is a chance that argument of biasness can be brought in, it's better that that particular person can be recused from the particular case. So he won't be part of the disciplinary committee for that particular case, and that ensures the integrity of the committee. So that would be a good practice that you can follow at your workplace. The inquiry officer should also not allow his personal and subjective opinions and knowledge about the accused employee unfairly prejudice the inquiry. That is another thing. See, us subconsciously it happens, we can't help it. But an inquiry officer should not think that, oh, this is the person who was indulged in this particular crime 3 years before. Hence, it is fairly possible that he would have done the same mistake now. No, so these are all fundamental principles that an inquiry officer should follow, so that there is never a question raised against the neutrality of the inquiry officer or committee. Now, often a question which is asked is that who can be appointed as an inquiry officer? So it's always best that he is an official of the organization, and he should ideally be a senior ranked person, so that he, especially in case of um let's say there is a particular allegation made against an employee, always make sure that an employee who is higher in rank to this particular person is appointed as the inquiry officer. Now this is for normal misconduct. For post related sexual harassment related misconduct, court have clarified that the IC committee can continue to being even if the accused employee is a senior most employee compared to this IC committee members. They still hold power. You need not dissolve the committee and then form a new committee. But however, when it comes to other misconduct, it's a good practice that you bring in a inquiry officer who is higher to the rank to the charge sheeted employee. And of course, that person should not have any linkage with the charges or allegations levied against the particular employee, and he or she should not be a witness to any of the incident which is subject matter of inquiry, and that person based on whose report or allegation the inquiry was initiated, he should not be that person who actually reported this particular incident, or should not have any personal relationship as a friend or a family member with the accused employee. Now let's look at how inquiry proceedings happen. Now let's look at what is the purpose of an inquiry. So it's very important for an inquiry officer or anybody else who is looking into this domestic inquiry, to understand the whole purpose of this exercise. So the first purpose of this inquiry is to aid the punishing authority to come to a definite conclusion regarding the guilt of the accused. So please do understand, there is no other intention here. There is a misconduct that has been reported, and the employer want to know whether this misconduct allegation is correct or not. The employer want to draw a conclusion regarding it, and then this process is conducted so that the employer can draw a definite conclusion. One mistake that often happens is that inquiry officers will go beyond the scope of investigation, which means that they go further beyond what is written in the charge sheet. But please do understand that the purpose of a domestic inquiry is to just look at the charges from the charge sheet and then look at the witness and evidence and examine them, and then come to a conclusion whether such a misconduct has happened or not. The purpose of an inquiry is not mere formality. It is not just conducted as an eyewash, so that later when a court proceeding happens, you have enough proof to prove that we have followed the principle of natural justice. No, that is not the purpose of a domestic inquiry. It is an actual fact-finding exercise. Similarly, the accused should also be given reasonable opportunity to defend himself, either by rebutting any evidence. Anybody who has complained against this accused employee, or the employer or the organization has proof against him, the accused employee should be given a chance to rebut all these evidences, and if needed, cross-examine the witnesses also. Often it is he said versus he said. So that person will come and give a witness. So a chance to cross-examine the witness should also be given. So the entire domestic inquiry proceeding is a fact-finding mission. Now let me introduce you to the key term in holding a domestic inquiry, which is a principle of natural justice. Now, what is principle of natural justice? Now, these are certain rules laid down by the court to protect rights of an individual against arbitrary procedure that may be adopted by an authority. So, because authority employer is in a power position, and they can arbitrarily take any decision and just dismiss, and rather the poetic word would be crush the weaker employee. So to avoid such things, there are certain rules that need to be followed before you take any disciplinary actions, which include every person whose civil rights are affected must have a reasonable notice of the case that he or she has to meet. So notice has to be given. Such a person must have reasonable opportunity of being heard in defense. So an opportunity to hear them should be given. An authority must act in good faith and not arbitrarily but fairly, justly, reasonably, and impartially. Now, these three rules has to be followed while taking any disciplinary actions. So, how does it translate in domestic inquiry? Notice would be the charge sheet. So, a charge sheet has to be given to the accused employee. The accused employee has to be informed clearly of these charges through this charge sheet, and the concerned employee is allowed to lead documentary and other evidence. So all the evidence he should have access to, so that he can understand what evidence has been presented against me and defend it. The examination of in respect to charges undertaken. So that opportunity has to be given. Employee is given fair chance to examine and cross-examine the witness. And when the inquiry officer records his or her findings, the report has to be also provided to the accused employee. So by which, if you follow these principles, if you follow these activities, charge sheet is given, he is given enough opportunity to raise his support in terms of witnesses or evidences to support his defense, and given an opportunity to cross-examine any person who is standing against him, or to verify all the evidence that is against him. And at the end, the report is also is been shared with him. You can fairly check this natural justice checkbox. Then nobody is going to accuse that this domestic inquiry have violated principles of natural justice. With that note, let me take a small break as of now. We will continue with our discussions on domestic inquiry from the next session. So until that, let me take a break. Right now, you have a fair understanding of how to proceed with a domestic inquiry in terms of giving the charge sheet, appointing inquiry officer, and above all, the principle of natural justice that has to be maintained during the entire domestic inquiry. Now, with those information, let's take a pause. Join me in the next session to continue our discussions on domestic inquiry. Until then, thank you so much. You have a great day ahead.